Hello everyone, so today I am going to discuss with you about Article 12 of the Constitution of India, which talks about the state and who will be covered under state. But before going to a detail what the state is and who will be covered under the state, we should know why the state is put under the fundamental rights, which is situated in the Part 3 of the Constitution of India, and the fundamental rights deals with the Article 12 to 35. So the reason behind is because the fundamental rights are enforceable against the state generally. For instance, the Article 16, which talks about that if there is any infringement in case of the employment in the government services, then the person can go against that authority. And there are some of the fundamental rights which goes against the individual as well. For instance, the 15th clause rule, which talks about that if there is any discrimination on the basis of religion, race, caste, sex, place of birth, or any of them in the public place to enter into a public place, then the person can file a petition against that individual. Now, Article 17, which talks about the untouchability, Article 20 to 24, right against the exploitation. If there is any exploitation is done by any of the individual towards any children, or there is any human trafficking is done by any of the individual, then the person can file a petition against that individual. So overall, the fundamental rights are enforceable against the state, so that a person should know who will be covered under the state, so that he can file a petition against that authority if there is any infringement of the fundamental right of that person. So the Article 12 is having the same meaning as provided under the Article 36, which is situated in the Part 4 of the Constitution of India, which talks about the directive principle of the state policy. So here the Article 12 is to be read with the Article 36 of the Constitution of India. Both are having the same meaning. But for the rest of the articles of the Constitution of India, the state meaning is entirely different. For instance, Article 309, 310, 311, here the state meaning is entirely different as provided under the Article 12 and Article 36 of the Constitution of India. Now Article 12, what Article 12 says. I hope this is clear why the Article 12 is put under the fundamental rights, because the fundamental rights are enforceable against the state generally, and the person should know who will be covered under the state and whether the particular authority is covered under that state or not, if there is any infringement of his fundamental right. Now the first one is the government and the Parliament of India. Here Article 12 says that the government here means the Union Executive and the Parliament of India is the Union Legislature. So it includes the departments and the institutes as well. And President, while acting in the official capacity, he will be also termed as the state within the purview of the Article 12 of the Constitution of India. So the first is the government and the Parliament of India. Government here the Union Executive and the Parliament of India is the Union Legislature. Now the second is the government and the state legislature. Here government means the state executive, and the state legislature, as the name itself says, legislature of the state, and it includes the union territories as well. Now the third point is the local and the other authorities within the territory of India, and fourth is the local and the other authorities outside the territory of India. So here within the territory of India, as we all know, but outside the territory of India means, for instance, if any private sector company is situated outside the territory of India and performing some government functions which is under the permissive control of the government of India, for instance, these are financially aided by the government of India, or there is any other kind of the assistance is provided by the government of India, then the that authority will be covered as the state. Now for instance, the embassies which are situated outside the territory of India, but these are under the permissive control of the government of India, if there is any fundamental right is infringed by that authority, then the person can file a petition against that authority as well. So other authority is if there is any authority which is situated outside the territory of India but under the permissive control of the government of India. either by financially aided, by administratively, or by any other kind of the assistance, but these must be under the permissive control of the government of India, then it will be covered as the state. Now the local authorities. See, the local authorities is defined under the section 3 clause 31 of the General Clause Act 1897, which talks about that it means district board, municipal board, or any of the board which are entrusted by the government of India or managed administratively by the government of India or any of the municipal board, then it will be covered as the local authority. So overall, the any of the board which are entrusted, which are financially aided by the government of India or administratively managed by the government of India, then it will be covered as a state. So it is defined under section 3 clause 31 of the General Clause Act 1897. So I hope it is clear that the state includes the government and parliament of India. Second is the government and state legislature, and the third is the local authority. Now the main ambiguity is regarding the other authorities, because there were so many controversies regarding the other authorities, because it is neither situated under the Constitution of India nor in any statute. So who will be covered under the state? There were so many controversies before the court. So the first time the expression was interpreted in the leading case law, University of the Madras versus Shantabai. So whatever I am going to discuss with you about the case laws, these the list of the case laws along with the citation is provided at the end of the video. So the University of the Madras versus Shantabai, in which it was held that the other authorities will be covered under the state only when if there is any esedem generis with the governmental function. Now what is esedem generis? Here the esedem generis means if the function of the other authorities is the similar nature as the government does, then it will be covered as the other authority. For instance, the car, vehicle, train, these all three are of the similar nature. If we put under it the table, then it is entirely different from rest of them. So the other authority must perform the similar kind of the function as the government does. This was held in the University of the Madras versus Shantabai, but this concept was totally rejected by the Supreme Court in the Ujambai versus State of the UP, in which it was held that the other authorities, how we can put into a single category. Even a central government and state government is performing the different functions to some extent. So how we can put all the authorities into a single category. So the concept of the esedem generis was totally rejected. Now the another case law is the Rajasthan SCB versus Mohanlal, in which it was held that the other authorities means which are created by the statute, but they must perform the governmental function or the non-governmental functions. Now the non-governmental function, what does it mean? It means that if there is any private sector company which is performing any of the governmental functions, then it will be covered as a non-governmental function. For example, public sector undertaking, PSUs. So if any of the company performs some of the governmental functions, then it will be covered under the state. Right. So Rajasthan SCB versus Union of India held that if any of the other authorities is performing governmental function or non-governmental function and must be created by the statute, then it will be covered under the state. Now the another case law which is very important, Sukhdev Singh versus Bhagatram Raghuvanshi, in which it was held that the other authorities includes oil and natural gas, IFC, Industrial Finance Corporation, and the LIC. So these three authorities, however, they are performing the commercial activities, though they will be included under the state because they are under the permissive control of the government of India. So the three authorities were considered as the state in the Sukhdev Singh versus Bhagatram Raghuvanshi, which was the oil and natural gas, second is Industrial Finance Corporation, and third is the LIC. Now the case law which I am going to discuss with you now is very important for the judiciary point of view or for the LLB student, they have to write whenever the question came before them about the Article 12. The R.D. Shetty versus International Airport Authority case, in which it was held that the Supreme Court held that basically that the state, if the agency or the instrumentality of this, if any of the authority is the agency or the instrumentality of the state, then it will be covered as the state under the purview of the Article 12 of the Constitution of India. So they must. Now the another question came before the Supreme Court, that who will be termed as the body or the instrumentality of the state. So there are some of the list gave by the Supreme Court to get to know who will be, to determine whether there is a particular authority is the agency or the instrumentality of the state. So if the financial assistance is provided by the government, then it will be covered as the state. And the second is, if there is any other kind of the assistance is provided by the government of India, then it will be covered as the state. And any kind of the assistance, for example, education facilities, medical facilities is provided by the government of India, then it will be covered as a state. Now the third is that if they are any administratively managed by the government of India, then it will be covered as a state. And the fourth is that if they are performing any, if that authority is performing any public function, then it will be covered as a state. But these list is not an exhaustive one, because it is not possible for the Supreme Court to lay down every possibility, right? So they lay down few tests to determine whether the particular authority is the body or the instrumentality of the state. Then it will be covered as a state under the purview of the Article 12 of the Constitution of India. Now the another case law, Ajay Hasia versus Khalid Muzaib, in which it was held that if the issue basically came before the court, that whether the Regional Engineering Institute is covered under the state or not, because it is registered under the Corporate Society Act. Now the Supreme Court held that yes, it will be covered under the state by taking into consideration the R.D. Shetty case, and held that it doesn't matter that whether a particular authority is registered under corporate society or whether it is corporated or incorporated. The matter is whether it is under the permissive control of the government or not. It was held that yes, it will be. It is considered as a government of. It is considered under the permissive control of the government of India. Then it was considered as the state. Now the another case law regarding CSIR, whether the CSIR is a state or not. CSIR, earlier it was considered that it was not a case, it was not a state under the Sarojit Tarabe versus Union of India, in which it was held that it was registered under the corporate society, so it was not considered as a, it should not be considered as a state. But in the Pradeep Kumar Biswas case, in which it was held that it should be considered as a state because it is under the permissive control of the government of India, and it doesn't matter whether it will be whether it is registered under the corporate society or not, or whether it is corporated or incorporated. The matter is whether it is under the permissive control of the government of India or under government of India. So it was considered as the state. So CSIR is a state. And NCRT, whether NCRT is a state or not, NCRT was not considered as a state. Now the another case law was regarding the BCCI. BCCI is a state or not. So the BCCI was considered as not a state in the case law G Telefilm versus Union of India, which is very important, in which it was held that it is not administratively managed by the government of India, neither there any financial aid is provided by the government of India, then so it should not be considered as the as a state. So BCCI was not considered as the state. And then the another case law which is very important on the whether the judiciary is considered as a state or not. So in the A.R. Antule versus R.S. Naik and the Prem Kumar Biswas versus Excise Commissioner, in which it was held that the judiciary, while acting judicially, it should not be considered as a state. but administratively it should be considered as a state. So while acting judicially, it is not a state. The reason behind, because the judgment is passed against one person and in favor of the another person, so obviously the person in whose against the judgment is passed, uh, he will say that his right is infringed. So therefore the judiciary was not considered as the state. Now the another case law is the Rupa Ashok Khura versus Ashok Khura, in which it was held that the if there is any order passed by the Supreme Court, then it should not be amicable to the writ jurisdiction. Means the judgment is passed by Supreme Court, that will be a final. If the person cannot file a case to that to the court for the infringement of his fundamental right. But there was many dissecting judgments regarding the High Court judgments. So it was held that the High Court decision that will be converted into the writ jurisdiction under the Article 32. So the whatever the decision is passed by the Supreme Court, that will not be entertained under the Article 32 of the Constitution of India. But if there is any judgment is passed by the High Court, then it will be considered as the writ under the Article 32 as a writ jurisdiction. Right. So this is overall about the state. And if we overview that the Article 12, why the reason behind is to put under the fundamental rights is because the Article 12 is enforceable, because the fundamental rights is basically enforceable against the state. So the person should know who will be covered under the state so that he can file a petition against that authority. Right. So there are four authorities which are covered under the state government and the Parliament of India, Union Executive, that is, and the Parliament of India is the Union Legislature. Second is the government and the state legislature. State legislature, as the name itself states, legislature of the state, and the government here is the state executive, and it includes the union territories as well. Now the local authorities, which are defined in the 3 clause 31 of the General Clause Act, and other authorities, there were so many controversies regarding other authorities. So first time it was interpreted in the Shantabai versus University of the Madras versus Shantabai. And now the whether the CSIR is a state or not. Yes, CSIR is a state. Earlier it was held that it is not a state. And an important case law is the RD Shetty versus International Airport Authority case, in which various tests is there to determine whether the particular authority is a state or not on the basis of the body or the instrumentality of the state. And now the judiciary, whether it will judiciary considered as a state or not. While acting judicially, it is not considered as a state, but administratively it is considered as the state. Right. And the Article 12 has to be read with Article 36 of the Constitution of India, but for the entire rest of the Constitution of rest of the articles of the Constitution of India, the meaning is entirely different. So I hope it is clear to you all. And if you like the video, please like and subscribe for the next upcoming videos. And at the end of the video, the list is provided of the case laws, and then there are some MCQ questions which were asked in the previous year examination question. So thank you all.